Rajasthan High Court will be co-chairing the seminar. Our speakers for today is one of the winners of today's National Law Day Awards, Mr. Lalit Bhasin and Mr. Deepak Jain. I request them both to please come on the dais, please. With my Lord's permission, I would like to start today's program.
Yes.
As you all know, we have gathered together on the occasion of International Conference of Jurists on Rule of Law. In this particular session, our topic is alternate dispute resolution mechanisms, how far successful. Alternate dispute resolution is coming up as one of the alternatives to the normal litigation process. And now I will request Mr. Lalit Bhasin to present his views and papers.
My lords, my fellow panelists, and my distinguished colleagues at the bar, it is my privilege to be sharing my views about the alternate dispute resolution mechanism that is in place in our country. I have got grave apprehensions about it. Therefore, if I appear to be pessimistic, please bear with me. As all of you know that we had the 1940 Act, which in opinion of some and in the wisdom of our legislature had become obsolete. Therefore, in order to meet the level ground playing field, you see, which was being created at the international level, our legislature, in its wisdom, brought in the 1996 Act, the Arbitration and Conciliation Act. It's an excellent piece of legislation based on the ancestral model of arbitration applicable in most parts of the world. That was in 1996, and now we are in 2007. So what has been our experience with the new law? Has arbitration been put at a place where it is recognized as an effective tool of alternate dispute resolution, or it has failed to meet the needs of the times and the demands of those who are engaged in commercial arbitration? In my opinion, arbitration in India has failed, primarily for certain reasons which I'll share with you. Arbitration in India has become as expensive, possibly more expensive than even litigation. Arbitration has become prolonged as litigation, and it has become more uncertain than even litigation because of several factors. There is no institutional support so far as arbitration is concerned. Arbitration has succeeded in other parts of the world because there are centers of excellence in the field of arbitration which have been set up in different parts of the world. I'm not just talking about the Arbitration Association of America or the London International Court of Arbitration. I'm even speaking of countries, in our neighborhood, Singapore, the Singapore International Center of SIAC, which is known. In Sri Lanka, you have very good institutions. In Malaysia. But in India, apart from two institutions which one hears of off and on, one is the Indian Council of Arbitration, which has been set up under the auspices of a Chamber of Commerce, that is FICCI, and the other is the ICADR, which has got an excellent building, but hardly any infrastructure, you see, to do any meaningful work in the field of arbitration. So there is more of ad hoc arbitration in India. And ad hoc arbitration would necessarily mean that parties, they don't go to the institutions, they select their arbitrators, and invariably they select judges, honorable judges who have retired either from the High Court or from the Supreme Court. They select eminent lawyers as arbitrators as well as to appear in the matters. The result is that it becomes like a closed market, that you have the judges and lawyers who dominate, you see, the arbitration proceedings. We do not find the experts. After all, this is commercial, there are commercial disputes which are to be resolved. You need the expertise of, say, architects, engineers, other people who can make more meaningful contribution than even lawyers or judges. But strangely enough, in India, that has not been encouraged. And I'll tell you, it's something which I have been told myself by a retired Honorable Judge of the Chief Justice of the Supreme Court of India. I met him in Bombay, and he told me, he said, Lalit, you don't know how much, I've never seen this much of money, as I'm getting now as an arbitrator. I say, sir, you definitely deserve that sort of money, but are you disposing of cases also? Then he said, we try to do that, but the lawyers come, they want the cases to be taken up at the weekend so that they can attend to their court cases during the weekdays. And on the weekend, they come, and then either because of our age, someone falls ill, you see, in the arbitral tribunal, or the lawyers take time. With the result, you see that the matters are postponed, and postponed indefinitely. Their diaries are full. Therefore, unless we have proper institutions which inspire confidence in the parties, this is now we are, you see, talking of the global disputes, disputes involving multinational companies, big industrial houses, business people, they are involved in litigation, in disputes. So you need institutions of real excellence with considerable expertise available to them from among a panel of arbitrators who should be listed in terms of their experience, not just judges and lawyers, but in other areas also. And those people should be really those who have specialized in their respective fields. And they should be actively involved in the matters of arbitration. And those institutions are lacking. Therefore, an effort is required to be made by such organizations as the All India Bar Association, or our Society of the Indian Law Firms, or the Bar Association of India, and the Bar Council of India can help us, you see, in setting up some good institutes for arbitration with emphasis on the educational aspect also, that is the training aspect. You see, our judges are definitely very competent. They can deliver judgments on questions of law, but they are not experts in all branches, you see, where the disputes arise. And the disputes arise not just on legal issues, Now, in a construction contract, you need someone, you see, who's either an architect or who's engaged in construction activity. He should be some structural engineer expert. You need those people also. So, although I am a lawyer and I am talking to a gathering of lawyers and honorable judges, but my plea to you is that arbitration can succeed only if you broad base the entire subject matter. Subject matter includes the panelists, you see, the arbitrators, and you should have the experts. Second reason is also because of the judicial interventions. With great respect, sir, I say, because I want this House to debate these issues. In Saw Pipes case, we saw the Supreme Court, you see, saying that in matters of public policy, the courts can interfere with not only with the awards, but even with the arbitral proceedings while they are pending. Now, what is public policy? That the Supreme Court does not define, and it is not defined anywhere. Therefore, public policy will be that which will be decided by the courts on case-to-case basis. Therefore, there is ambiguity, there is uncertainty as to what this may constitute, you see, some breach of public policy. The second case saw the Patel engineering case decided about a couple of years ago by the Honorable Supreme Court, where virtually the courts, you see, they usurped the jurisdiction which ought to have vested with the arbitral tribunals to decide those issues. So the arbitration proceedings coupled with the judicial interventions, they make the proceedings prolonged and very uncertain about the outcome, which is more pronounced than even in the case of litigation. So my plea to all of you is to share your views on these important issues as to why arbitration has not succeeded in India. That is why people are already looking for alternatives to arbitration. And those alternatives are to be found in conciliation and mediation. There, the courts have taken a lead. They have set up mediation centers. In Delhi High Court, we have a very effective mediation center, you see, which is doing considerable good work. The disputes are sought to be resolved. So the emphasis is shifting now from even arbitration to conciliation and mediation. But again, for that also, you need trained mediators and trained conciliators. So training is required to be imparted, and we hardly have any institution in India, you see, which imparts training to our arbitrators or those who are mediators and conciliators. As a lawyer, if you tell me to start mediation, well, I can just try, tell the parties, but I need some training. I myself would need some training in order to convince the parties that whatever I am saying, they should listen to me with some confidence. So such institutes, other than those involved in arbitration, are also the need of the time. And that is, if arbitration has not succeeded, at least let us try that mediation and conciliation would succeed. And there our courts have taken the initiative, and we hope, you see, that this would succeed. Thank you very much.
Thank you, Mr. Bhasin. And Mr. Bhasin felt the plight of having trained arbitrators, mediators, and negotiators. Now I'm introducing my second speaker, Mr. Deepak Jain, who is a trained negotiator, mediator, and an arbitrator from Harvard, and he will be putting academicians and a critique view of the mechanisms which are there in India. Mr. Deepak Jain. Yes.
Thank you, Anil.